Welcome to the Loud Little Ducky. We're going to go over a filing Woodnick makes, wanting Laura Owens to show him the money that is owed to him and his office in the Owens v. Echard matter. Owens right now owes Woodnick Law $196,260.11, and that is before interest, and interest has started accruing on the original $149,000 judgment that she had. So let's jump in and see what Woodnick wants Owens to show him and tell him why she has not been able to pay off any of the debt that she owes Woodnick. So here we have Woodnick Law, Gregg Woodnick and Isabel Rainey, attorney for respondent Clayton Echard. This is in the matter of Laura Owens versus Clayton Echard. And it's been over a year since this case finalized, as far as in the Superior Court. And so on October 6, 2025, in the Superior Courts of the State of Arizona in and for the County of Maricopa, Woodnick says that this is a motion for supplemental proceedings judgment debitor examination assigned to the Honorable Monica Garfinkel. Now, I don't know why it is assigned to a new judge now. I know Gingras was out there trying to be like, oh, look at this. There's a new judge on the case. We don't know why. Some places, judges rotate and they get put in different areas, or they go back and forth between criminal and civil. But we don't know why. It could just be a part of the scheduling. Judgment creditor Clayton Echard, respondent, by and through undersigned counsel and pursuant to ARS 12-1631, hereby respectfully moves this court to issue an order requiring Laura Owens, petitioner, to appear for a judgment debitor examination related to the 4 judgments entered against her connected to her current criminal charges for fraud and perjury, and the case number. In support of this motion, respondent states as follows. Parties in judgment. Respondent is the judgment creditor in the above captioned matter. Petitioner Laura Owens is the judgment debitor. Petitioner is also known to use aliases Emily Wilson. On August 16th, 2024, filed by the clerk on August 19th, 2024, this court entered a judgment in favor of respondent and against petitioner for attorney's fees and costs in the amount of $149,219.76, with interest to accrue at the legal rate until paid in full. Exhibit 1 is what they give this. On May 6, 2025, the Arizona Court of Appeals entered judgment in favor of respondent against petitioner, so in favor of Clayton against Laura, for attorney's fees and costs totaling $36,466.79. See Exhibit 2. On May 28, 2025, the Arizona Court of Appeals entered another judgment in favor of Clayton and against Laura for additional fees in the amount of $3,976.50. See Exhibit 3, which that one was for him trying to get them to reconsider So we've got the 149,000, which is Judge Mata. Then we've got the Court of Appeals when he first appealed to them at 36,000, and then when he asked them to reconsider at the Court of Appeals, that's where the 3,900 comes in. And then on September 19, 2025, the Arizona Supreme Court entered judgment in favor of respondent and against petitioner for attorney's fees and costs totaling in the amount of $6,597.06. See Exhibit 4. These judgments remain unsatisfied in whole, which means she hasn't paid a fucking dime. All right. Will they go to the U.S. Supreme Court, or are they done? I don't know how long it is that they've got to decide if they're taking it to the U.S. Supreme Court, because David did say if he needed to, he would. I don't know if he's since changed his mind. They have the right to. I think it's smart not to go there because she's just going to accrue more fees, in my opinion. But that is their call to make. Legal basis for petition. Under Arizona law, a judgment creditor is entitled to conduct supplemental proceeding, including a judgment debtor examination, to identify assets that may be used to satisfy the judgment. ARS 12-1631, ARS 12-1634B, Arizona revised statutes authorize the issuance of writs of execution and other processes to enforce judgments, and supplemental proceedings are necessary tool for ensuring compliance with court orders. ARS 12-1551, respondent has made diligent efforts to collect on the judgment at issue, but has been unable to fully satisfy the judgment. So I guess they've tried getting her to pay. Maybe they've tried contacting her. I don't know. To ask when she's going to pay. Maybe they mail her bills and invoices to her house and she doesn't respond to them. Who knows? Request for relief. Respondent respectfully requests that this court issue an order requiring petitioner Laura Owens to appear for a judgment debtor examination at a time and place specified by the court. Respondent further requests that the petitioner be required to bring to the examination all documents and records related to their financial status, including but not limited to the following: whether under the name Laura Owens, Emily Wilson, or any other aliases used by petitioner. Number 1, federal and state income tax return for the past 2 years, including all schedules and attachments. Number 2, bank statements for all checking accounts, savings account, money markets accounts, certificates of deposit, or other financial accounts in any bank, credit union, or savings and loan association in which judgment debtor has or has had any interest, including as a beneficiary for the past 12 months, so the past year. 3, pay stubs or earning statements for the past 6 months, and proof of all income from employment, self-employment, or any other source. 4, certificates, statements, or documents evidencing ownership or interest in stocks, bonds, mutual funds, or other investment accounts. 5, life insurance policies for which judgment debtor is the insured or a beneficiary, including documentation of cash surrendered value. So this could cover if Ron Owens or Jan Black have life insurance policies in which Laura is a beneficiary. That needs to be brought in. 6, trust documents from which judgment debtor is beneficiary and or trustee. 7, titles and registration documents for all motor vehicles, boats, recreational vehicles, motorcycles, or other titled personal property owned or leased by judgment debtor. So this could be her Airbnbs if she still has those. Deeds, titles, contracts of sales, mortgages, contracts for a lease, or other documents evidencing ownership or interest or rental income from real properties. 9. Deeds, titles, contracts, or sale contracts for the lease or other documents evidencing ownership of interest in animal personal property such as horses and donkeys, including any contracts or performance related to the same. Business records if self-employed or owning an interest in any business entity, including profit and loss statements, balance sheets, and business tax returns, including all financial and business documents related to Liz Mack Investments, Quartet Farms, Stylette, all LLCs. And if she doesn't have those, when did she get rid of them? And what did she profit off of them? All of that. Because they've been moving money over there in the Owens house and trying to sell things off, whether it's for Laura Owens' parents for their bankruptcy or to make Laura Owens look indigent and that she has no money. They had stuff, and now all of a sudden, nobody in that house has anything, they state. Documents evidencing debts owed to judgment debtors, including promissory notes, contracts, accounts receivable, or other evidence of money owed to judgment debtor by third parties. Credit card statements for the past 12 months for all credit cards held by judgment debtor. So any credit card that Laura Owens has had in the last year. List of all credit cards used by the debtor over the last 12 months, if permitted by third parties, and names and contact information of third parties permitting the same. So if she has used her mom or her dad's credit card or her sister's credit card to do something, they want to know that information as well over the last year. She'll be like, well, I don't have a credit card. I don't use mine. Well, did you use your mother's? Like, how have you been getting your Domino's pizza, Laura? How have you been getting your dog food? Records and paperwork relating to horses and equine related equipment owned by petitioner and or any LLC or entity where she was or is an officer or a member, including any records of sales or transactions related to horses owned by petitioner in the last 2 years. So they're going to list some horses. So apparently they've had these horses at one point or another. Don't know if they still have them. All registration and transaction records relating to the value of all horses, including but not limited to the following. So if they have them, what is their value? If they've sold them, who did they sell them to? How much did you sell them for? Want the paperwork. Whisper, Nugget, Crackers, Tigger, Pokey, Tiffany, Rumor, Sirocco, Frosted Flakes, Small Winnie or Whiny, Eskimo Kisses, La Corrador, La Corrado, Small Penny, and Spotify, which she acquired in 2021. Inventory of all horse-related equipment currently owned by petitioner in the last 2 years. Inventory of horse-related equipment sold or marketed to be sold by petitioner in the last 2 years, including but not limited to Facebook Marketplace sales, Craigslist sales, and third-party sellers, the Tried Equestrian Closet, and the Horse Forum, etc. So if she has sold any of this stuff and she's gotten money for selling it, which we know she was selling stuff at one point. Copies of all statements for third-party pay platforms, Venmo, Cash App, PayPal, Apple Pay, Wise, Google Pay, Meta Pay, Stripe, Samsung Pay, Google Wallet, Remitly, etc. for the last 2 years. I would also put Square in there. Copies of all statements for receipt or funds from a third-party donor platforms, including GoFundMe. List of all amounts of legal fees paid and the names of all IOLTA accounts where such funds are deposited, including funds related to the State versus Laura Owens and the Laura Owens versus Michael Maricini. Any and all other documents reflecting assets, incomes, liabilities, or financial transactions of judgment debtor. Wherefore, respondent respectfully requests the court issue an order requiring petitioner to appear for a judgment debtor examination at the time and place specified by the court, require petitioner to produce the document and records identified above. C. Award respondent costs and fees associated with this motion. And D. Other such further relief as the court deems just. Respectfully submitted, Woodnick, and this has been sent to Gingras. Okay. And then this is the August 19th, 2024 application for attorney's fees and costs, and that it is ordered that Laura pay the $149,219.76. And it says it is further ordered that the petitioner shall satisfy the judgment within one, I'm guessing, year. No, my bad. 180 days of entry of this judgment and order. If petitioner fails to do so, the judgment shall accrue interest at the legal rate until fully paid in full. And this was done in open court, August 16, 2024, and Judge Mata had signed that one. So as of 180 days after this was entered, she could have paid it all, and it was going to be the $149,000 and stuff. But now that it's way past the 180 days, it is now the original judgment is more than 149,000 just in the case where Judge Mata was the judge and issued this. Okay? So she owes more than that just on the original. And it just keeps going up every single day she doesn't pay. And then we've got May 6, 2025, which is the $36,283. The amount, okay, it said that Arizona Division 2 has leave to supplement a request. Okay, so they don't give a date on when this needs to be paid. It's just she has to pay this. And that document was submitted to Gingras and Woodnick and Deandra Arena and Isabel Rainey and her appellate attorney, Marcus Reisinger. And all of Clayton's people are people from Woodnick's firm. And then the May 28th, 2025, the additional fees of the $3,976.50. And there's no date given when she has to pay that. It just needs to be paid. This was sent to the proper people as well. And then we go to the Supreme Court of Arizona. And on September 19th, 2025, they ordered the $6,416.50 and cost in the amount of $180.56. it does not give a date on when this needs to be paid. And of course, this was sent to the proper people as well. So that is what she owes. And Woodnick has given her over a year to make good on it. But I know it's probably not likely when you have a criminal case. So is David going to respond to this? Is he going to get the documents and submit them? Or is it just going to be set for a hearing? Let me know what you think down below. Like this video, subscribe, turn the notification bells on, and I will see you in the next one.